Ghislaine Maxwell may no longer be protecting the John Does, the people who received her services or Epstein's services, at least according to a new filing. Remember that Ghislaine Maxwell is involved in a number of different legal ordeals. Just found out that she was convicted of 5 of 6 counts in her criminal case, but she's the defendant in a lawsuit brought by Virginia Roberts Giuffre, suing her for defamation. And Maxwell had a particular posture as a defendant before she got convicted, but now that she's been convicted, something's changed. A number of different people are very, very opposed to any of the documents in this lawsuit being unsealed. And they've told the court as much. They've told Maxwell's lawyers, they've told Robert's lawyers, we don't want any of this unsealed. Maxwell, up until very recently, said, don't worry about that. I've got your back. We're going to step in front and act as a shield. Until very recently. New filing from Laura Menninger, you can see here, is reversing course a little bit, filed on January 12th. It says this is the defendant's position, meaning Maxwell's, about these new documents being unsealed. We've got a number of different non-parties here, somebody named 17 and 53 and 54 and 55 and 56 and 73 and 93 and 151, all who don't want these documents unsealed. Now, in this letter signed by Laura Menninger, counsel for Ghislaine Maxwell, we spent a lot of time listening to her during the Ghislaine Maxwell trial, is telling us that she no longer wishes to address any of those objections, meaning we no longer have your back. So let's take a look. We're going to dive into that a little bit further, but this is where this lawsuit originates from. And look how long ago this was filed. This is the original complaint, 9/21/2015. Count 1, defamation. Virginia Giuffre alleges the paragraphs saying that Maxwell defamed her, saying that Maxwell is out there making statements that were trying to impede and destroy Giuffre's reputation, saying that this was going to neutralize and dilute and discredit Giuffre's public and her appearance and try to undermine her credibility in the public. And so now that count 1 has been filed and this lawsuit has worked its way all the way up, we're getting really close to unsealing some documents. And you can see here that the plaintiff in this lawsuit is Virginia L. Giuffre against Ghislaine Maxwell. And right now, this is what we're looking at is plaintiff's brief. So this is Virginia Giuffre's brief in response to the non-parties. So these are people who are not a party to this lawsuit. You can see, and these are the names of the John Does, or the numbers really, 17, 53, and so on. They're not a party to this lawsuit. They're not listed up here in the case caption. But they've got an opinion about whether these documents are unsealed or not. And so they're raising objections. When the court started to say, we're going to unseal all this stuff, they started firing letters in saying, hold on a minute, we've got an opinion on this stuff. And so if you fast forward all the way from 2015 to about September 2021, we can see that Ghislaine Maxwell and her defense team were very involved in protecting these John Does. We can see that the judge actually wanted a scheduling order from both sides. In other words, the judge wanted to hear from the prosecution and from the defense about protecting these people. They say, listen, the court is in receipt of submissions from counsel to Giuffre and Maxwell. We know the Miami Herald's involved. We know John Doe even hired lawyers, somebody named C. Waltz over here, somebody named N. Lewin. They're sending letters in. Everybody is sending letters in. Nobody wants this stuff unsealed. So we've got a letter now from the attorney for the plaintiff, Virginia Giuffre, as well as Laura Menninger for the defense. They're also saying we need to meet and confer about this stuff. How do we streamline, you can see here, the unsealing process so that this stuff can get out in the public record? The court says, I've got an idea. Here's what we're going to do. The court is now going to consider the objections of the 16 non-parties who submitted the objections. Here's what we're going to do. Because there's 16 of you, the parties, all of the different parties who are objecting here, are going to submit omnibus briefs. They're going to address the objections of the first 8 non-parties, and then we can go through the other 8. Go through the first half and then the second half. So the first 8 objectors, they're going to have a briefing schedule, and I want you guys to brief it so that we don't really overly burden Miss Maxwell's counsel, okay? Because Maxwell's counsel is going to be very involved in this. And the point here is that back in September 9/28, you can see that Maxwell's defense team is very involved. They're sort of acting as the mediator. They're going out there. They have all of the different John Does who are filing their objections. They're going to be consolidating them and preparing, sort of briefing all of the issues before they present the issues to the court. And then the court can make rulings about unsealing the records as they pertain to each particular John Doe. The defense very involved in this. In fact, they even submitted a joint briefing as late as October 29th, 2021. This coming on letterhead from Sigrid McCawley's office. This is from the plaintiff's office representing Virginia Roberts. Says the parties write in response to the scheduling order that came out from the court. Here's what we propose. Virginia says that they want to brief Does 17, 53, 54, 55, 6, okay, and so on. Maxwell's counsel responded saying, no, we can't do that because we've got a criminal trial coming up and it's full of conflicts. Remember that? We spent a lot of time on this channel talking about that one. But she says, Maxwell's counsel, well, here's what we propose then. With respect to the first, we got the length of the trial happening. We're going to qualify a jury through January 15th, but that's not going to happen. We saw that a lot of this got changed. Deadlines were moving all over the place. But you can see my point that Maxwell's defense team was going to be very, very involved. They want additional language clarifying the version of the omnibus briefs concerning how the briefing will be handled, who engenders non-party Does, making it clear to everybody that the briefs will be redacted, alleviate some of the follow-up pleadings that would okay? Very, very involved is the point. The specifics doesn't matter. The point is, Maxwell's defense team, they had a force field around these John Does. They had a shield around them. And now they don't. We can see here they submitted this letter on January 12th. They say, well, you know what? They all objected. But you know what? Maxwell does not wish to further address those objections. Thanks. Says that each of the listed Does has counsel who have ably asserted their own respective privacy rights. Ms. Maxwell, therefore, leaves it to this court to conduct the appropriate review consistent with the order and the protocol detailing the unsealing decided motions. Respectfully submitted, Laura Menninger. Saying that they've all got lawyers, they're capable of consolidating this themselves. Judge, if you think it should be unsealed, we don't have an opinion on it one way or the other. Don't bother us with it anymore. It's up to them. Very, very different posture. A lot of people are wondering why. Why would Ghislaine Maxwell and her team suddenly decide to raise the white flag, to drop the force field? Are they out of resources? Do they no longer want to expense that? Or is there something more interesting happening? We'll have to wait and find out. We also know, though, that they're not going to be defending or responding to these types of arguments. This is in the motion, the response to the objections. Remember now that all of these John Does are objecting. Objection, objection, objection. We don't want any of this unsealed. Ms. McCawley in her office, representing Virginia Roberts, they are responding to those objections. And they're saying, Judge, here's why those objections should be overruled. You can see here, just generally, we're going to go through this quickly, 16 pages in total, but we'll just fly through a couple examples. You can see some of these Does don't even oppose unsealing. She says Doe 53 doesn't oppose it. Doe 54 doesn't oppose it, generally speaking. Doe 17 should be overruled for other reasons, which we'll take a look at. And you can see there's just sort of a variety of different reasons why. She gives a very nice preliminary statement saying that back in July of 2021, the court suggested streamlining and accelerating this process. We were going to split the objecting parties into groups. Does 17, 53, and so on would be unsealed. Some of this stuff has already been rejected. Now, they say that some people here could be and will probably be placed in an unfortunate position where they have an association with Epstein and Ghislaine Maxwell. But the court's unsealing process previously has been quite consistent, with the exception of a narrow set of circumstances which are generally not present here. Documents have been unsealed, notwithstanding generalized concerns about annoyance or embarrassment. So just because some of these Does might feel like, uh-oh, we're connected with Epstein and Maxwell and this is problematic and I don't want my name dragged through the dirt, the court says, or the plaintiff here, Ms. McCawley, is saying, we've had precedent. The court has found previously that's not enough. That's not enough justification Just because it looks bad, just because it might lead to embarrassment or annoyance, it's not enough. We need something more substantial than just that. She also writes, now that Maxwell's criminal trial has come and gone, there's little reason to try to protect all of this information. I mean, all this stuff was just aired out in public. At Maxwell's trial, non-parties to this action, including victims and everybody, they all testified in open court. All that information has remained sealed from the public in those cases. Those witnesses, though, used their full names and full names of others, except for the victims who were minors at the time. And even if you think about it, Judge Nathan denied Maxwell's request to allow certain of her witnesses to testify under pseudonyms, saying that that wasn't good enough. In other words, not protecting the privacy of people. Maxwell's defense wanted her witnesses to be able to testify anonymously. Court said no. Same reason this court should say, no, you don't get to remain anonymous, John Does. Judge Nathan squarely rejected the defense's argument, saying, which was that anonymity is necessary to protect witnesses. Judge said that doesn't present itself here. So they're analogizing, saying that this court should likewise reject this objection here. Overrule this, unseal the judicial documents pertaining to them. Couple quick examples of what some of these Does are saying specifically. So Doe 73, for example, McCawley is saying this one should be overruled because the name appears in 7 documents that are attached to discovery motions, all in connection with letters discussing search terms. Their address is being listed as unknown. And the reason why Doe is objecting to this is because they just have a general aversion to being associated with them. They don't want to be connected with these two people. They say we have no knowledge of it. Okay, so that's sort of what McCawley is saying, is that's not enough justification to not release it. Doe 93, John Doe 93, mentioned in 3 depositions, they write they have no relevance there. They say given the sensitive and potentially salacious issues here, that this has been very public. And again, they say, listen, there has been nothing specific here that has been alleged. So broad, unsubstantiated reasoning, been rejected time and again. You just can't be somebody who just doesn't want to be associated with them. So they say the objection should be overruled, material unsealed. They have not articulated a compelling reason to rebut the presumption of public access. Just because you're generally annoyed isn't good enough. We can also see a conclusion here from Miss McCawley, her office over there in Fort Lauderdale, Florida. And so Ghislaine Maxwell hinting that maybe these John Does no longer under the protection of her legal super dream team. Very clearly not, in fact. Not getting involved in responding to any of the objections or supporting any of the objections that have been proffered forth by the John Does. We know Miss McCawley and other attorneys have been wanting to unseal many of these records. And many people are asking themselves if the first part of the facade is starting to crumble. Now that Maxwell has been convicted, is that the first domino in a longer list of further consequences? We'll see. We'll continue to follow it along. I hope you join us in that journey. Be sure to subscribe before you get on out of here. I'd love a like as well. I look forward to seeing you on the next one.